Good morning, good afternoon, good evening, depending on what part of the world you are. Welcome again to another video. My name is Ibukun. I'm discussing law and legal issues on this channel and other interesting items, and so I would like you to join my community by clicking that red subscribe button. And also, if you enjoyed this video, don't forget to give it a like and share it with one person. Now, today's topic is the exciting Companies and Allied Matters Act 2020. So here in Nigeria, President Buhari signed on August 7th a new Companies and Allied Matters Act, which is the law that governs corporate governance, business organization, and everything that has to do with the business community. And so a lot of people are excited about this new legislation, which repeals the old one that was signed into law in 1990, 30 whole years. And this new law is very exciting. So I just wanted to touch on a few of the provisions that I think are going to help you and that might encourage you to, do better in your business because it makes it easier, or actually encourage you to start your business because it is cheaper and more accessible. So grab your cup of tea or coffee. I have my cup here. It says lawyer. And we're going to be sipping while we discuss the provisions of the 2020 Companies and Allied Matters Act. We're going to start from the general cover of this legislation. The Ninth Assembly passed the bill and then the President signed it into law. So it is officially a law that governs business entities in Nigeria. So I'm going to start with the structure of this legislation. It has 870 sections. It's divided into 7 parts, and it has 15 schedules. The opening statement says that it repeals the Company and Allied Matters Act 1990 and it enacts the Company and Allied Matters Act 2020, which is going to regulate the incorporation of companies limited by shares, business names. It introduces 2 new entities, which is the Limited Liability Partnership and the Limited Partnership. It also governs the incorporated trustees. So Part A of this legislation covers Section 1 to 17, which is the Corporate Affairs Commission, its establishment, its operations, and incidental matters to the Corporate Affairs Commission's operations and funding and other matters. Part B deals with companies limited by shares or companies incorporated that have share capital. So this has to do with unlimited, limited by guarantee, limited by shares. And this goes from Section 18 to Section 745. Part C, which has the Limited Liability Partnership, goes from Section 746 to Section 794. Section D has the Limited Partnership, which is Section 796 to 810, and we have Section E, which deals with business names, that goes from Section 811 to 822. We also have the Incorporated Trustees, which is in Part F, and this goes from Section 823 to 850. Now, there are general provisions which cover the 851 to 870, and that's the end of all the provisions. Then we have the schedules, which have the forms, have extra matters like the laws and the rules that govern some of the provisions and explanations in the legislation. So it is not at all possible for me to cover all the provisions of this very exciting legislation in one video. So I'm just going to limit myself to either innovative provisions or important provisions that a business person or a person interested in starting a business should know. Now, the first step would be who can incorporate a company. One person can incorporate a company limited by shares. This is such exciting news because a lot of people struggle with finding partnerships or a second buy into their idea, and they want to start their business. They have a good idea, and so as a shareholder, you can be just one member of a company and register your business. This is good news for you if you're thinking about starting that business but you've been looking for partnership. You can just go ahead and do what you need to do. Also, you need to know that you should be above 18 to register a business. You should be a person that is of sound mind. That is, there is no court of law in the world that has declared you unsound or unfit mentally. Along those lines also, if you're a foreigner, you can incorporate a business in Nigeria. All that you need to know is that you also need a citizen of Nigeria to be a member of that company. So a foreigner cannot single-handedly be a member of a company. You have to have partnership with residents and people that are citizens of Nigeria. The next exciting news is that as opposed to having authorized share capital, there is now what is called a minimum share capital, meaning that you don't have to pay for all your shares. You just have to pay for shares that you are going to be using at the time of incorporation. And so if you have a 1 million share capital business, you don't have to pay for all the shares. You just pay for the minimum share capital that you are taking up at the time of incorporation. Speaking of the minimum share capital that you have to have, for a private company it is 100,000 naira, and for a public company it is 2 million naira. And this is exciting because it just cuts your costs down a lot. Also, you don't need a lawyer to sign or a notary public to sign a declaration of compliance when you're registering your business. That's exciting news, I bet. Now you have what you call the statement of compliance, meaning that you or your agent that is registering your business on your behalf can sign that you have complied with all the provisions and regulations under the Act for registering a business, and you're good to go. So this is going to cut out costs for a lot of people who have to pay a little extra to get that signature and that documentation done. In the same line, we're dispensing with all these unnecessary steps that were introduced in the law, or maybe I shouldn't say unnecessary, things that have become stale in terms of best business practice. And so using a common seal or something that was required under the Act prior to this legislation, but under CAMA 2020, you no longer need to have a common seal if you're a private business. Very important for you to note, you cannot issue preference shares that are irredeemable. So note this when you are, designating shares or allotting shares to the shareholders. Preference shares cannot be irredeemable when they're being issued. In the spirit of, transparency and openness, there has been introduced into the law the requirements that if you have at least 5% of the voting rights in a general meeting, either through you yourself or through your nominee, you have to disclose this information to the company, who has to disclose this information to CAC, a public company that is. You have to disclose this information in writing to the company, and the company has to also notify CAC. So there's more openness and transparency in terms of who are the shareholders and who are the very powerful shareholders, and this is good for doing business. Also in line with transparency and just good business practices, as a public company where a person is the chairman, that person cannot also be the CEO of the public company. Okay, so a public company cannot have the same person as chairman and CEO. In Nigeria, that is no longer allowed. A person is not allowed to be a director in more than 5 public companies. And so you can see that a lot of regulation in terms of ensuring best business practices in publicly traded companies. And so, it has to do with disclosure of significant shareholding has to do with chairman and CEO. That's because there's a lot of power when you hold those two seats. And also, you cannot be a director of more than 5 companies that are publicly listed. So the exciting single member company, as it is being called, that is where you are the only person in your incorporated company by shares. You don't need to have minutes of meeting because it's just you. What would happen is where you have a board of directors, but you're the only shareholder and you're making decisions that will be made in a general meeting, then you have to, communicate those decisions to the board of directors, but you don't have to write a minute. So that isn't necessary. Also, for small companies, the need to appoint a company secretary has been done away with. I'm sure a lot of SMEs are like, thank God, because this is also something that means that you're paying a little extra to a lawyer to be your company secretary or to a firm. So if you're a small company, then if you're a small private company, you don't need to have a company secretary. For those that are out there that are still waiting on registering their business, you need to jump on this bandwagon and get your business registered ASAP. An important provision that you should know is that for public companies, and this is good information for either public companies or for legal practitioners that want to be company secretaries in a publicly traded company, you should know that there are qualifications that you must have for you to occupy that position. So to be a company secretary in a public limited liability company, you have to be a legal practitioner. You have to be a member of the Institute of Chartered Administrators in Nigeria or the UK. It's not specified. And you also have to be a member of a body of accountants. So if this is something that is a career path for you, you want to start working on joining those bodies as soon as possible. To be determined to be a small company for the purpose of financial filings and regulations under this law, there are 5 things that need to be met. One is that there is no foreigner that is a part of that business. 2 is that your assets are valued not above 60 million naira. 3 is that your turnover in a year is under 120 million naira. 4 is that there is no government agency or parastatal or anything government that is a nominee of that company. And finally, the directors of that company, if they hold 51% of the shares of the company, then it will be considered to be a small company. So you want to think about this in terms of how does this law affect me? Am I a small company? In order to benefit from not having to appoint auditors, or in order to benefit from not appointing a company secretary. Once you're a business registered in Nigeria, it is important for you to know that you should publish the name of your business, the registration number that CAC gives you, your registered business address on your correspondences, so your letterhead. There should be a signage on your business address saying that this is the name of the business, this is the registration number. If you are sending out publications, I'm going to read out a few others so that you know that these things are important for you to publish on this document. I don't see a lot of businesses doing this, but there are businesses that comply with it. Just in case your business hasn't published its name and its registration number on this document I'm about to read out, you should ensure that you comply with this. It's not a new provision, but it's a provision that is important for you to note. Now it says that your name and your registered number should be legible in character, and it should be in your notices that you send out, in your advertisement, in official publications of the company, in bills of exchange, in promissory notes, in endorsements, on checks, on orders for money or goods purporting to be signed on behalf of the company, on bills or parcels, on invoices, receipts, and letters of credit of the company. So these are quite a number of documents that you need to publish legibly your name and your registration number. So if you've not already complied with this provision, please ensure that you do that as soon as possible. Another interesting aspect of this legislation is that for incorporated trustees, they can now merge. So if you have an incorporated trustee that is basically an NGO or an association or community, you can come together if you have similar objects. So say you're both in the health sector providing health benefits to the community, you're both a legal body established as an association, you're both churches, for example, you can now merge because your objects are similar and create one entity. There's provision for e-filing of documents. There's provision for holding virtual general meetings for public companies, because of course this was passed during COVID, and it's now more than ever obvious that we have to do things online or without being on site. And so virtual meetings are now recognized under the law. You can also file your documents online and they would be accepted, and there will be proof that this is a valid filing. The legislation is very big on ease of doing business in Nigeria, and the committee that was pushing it from the executive arm is the Committee on Ease of Doing Business. And so I want you to tell me, what do you think? Do you think it's easier for you to do business based on the things that you've heard in this video or that you've seen online, or is there something that you're still expecting that you didn't get? Again, don't forget to subscribe to my channel, like this video. I'm sure you enjoyed the content, especially if you stayed to the end. Thank you so much to all my subscribers. I'm so grateful to have you. To everyone that is new and watching me, hi, join the family. We're learning in fun, exciting ways legal concepts and laws that have to do with your daily life.